All right, in this morning's You Want to Know, it's all about your kids and possible injuries. You know, they're inevitably going to happen during the school year. So joining us to talk more about that is John Grazian. He's a partner with Grazian and Volpe, Chicagoland's injury lawyers. So how are you, John? Thanks for joining us. Sorry we didn't offer you some gluten-free food, but apparently Jean has. Jean, have you taken? Yeah, oh, she's still eating it right now. You what? Yeah, you can have some hardwood apples because Jean has eaten all the gluten-free products.
Sorry.
Okay. But you know what? Listen, our first question, I think this will affect a lot of people. It comes from Michael. He's in Naperville. He has a question for you, and he's talking about his son who was hit by a ball during a school baseball game and then hurt his hand. And I think a lot of parents, they may face this as their kids get injured or something happens at school. What would happen, or what would happen? Would we have any legal recourse if that happened?
In a situation like this, probably not. When you're talking about any kind of a recreational activity at a school or a park district, it's really hard to make a case, because what you're going to have to prove is you're going to have to prove willful and wanton conduct.
Okay.
And that's different than mere negligence, carelessness. Willful and wanton conduct means a conscious and utter disregard for the safety of another. So it's a little bit less than a purpose or an intentional act, but it's still a pretty high bar.
So that bar, that standard then, is for schools and park districts,
schools,
for a public.
Park districts. So I mean, you can have a situation, for instance, where the high school football coaches running wind sprints for people in 95-degree weather.
Right.
That might be considered willful and wanton, but when you're talking about most accidents, it just doesn't rise to that level, and it's going to be pretty hard to hold a park district or school liable for a recreational injury. Okay,
interesting. That's actually good to know too, because there on the flip side, there are some parents who everything happens and they're like, I'm going to sue. You know, it's become a very litigious society, so it's good to know that
it's sports.
It's both right. It's right. Yeah. And if the kid didn't win, then the first thing you do is sue. That's what we do. But okay, let's take another question. This comes from Cheryl of Oak Lawn, and she's writing, my daughter actually hurt her lip while she was riding the school bus. She was goofing around. She slipped off her seat. So do I have any legal rights, again, being injured on the school bus?
And this is actually sort of the flip side, because with a bus, you're talking about a common carrier. And as a common carrier, they have a duty of the highest degree of care practical under the circumstances. So a school bus is going to be held to a much higher standard than a mere negligence or carelessness standard that you see in most types of cases. However, here you're talking about a situation where a child's goofing off, and there's really nothing that the bus driver should have done or could have done to prevent something from it. You know, kids are being kids.
But that's interesting, though, that there's the higher standard. So it's different than just, again, like we were talking about at the PE class or something like that. Your kid on the bus, there are higher standards for their safety. Yes. I never really even thought about that. It's kind of interesting.
There is.
Okay, we actually, I think, have a visual aid to help us. Cheryl, I'm not sure what this is. What? Right. See, those are kids. That's what we used to do in the good old days.
Yeah.
I don't know about you, John. We used to sit in the back. That was the bumpy ride when the kids... when we didn't have seatbelts. Like now the kids are seatbelted in.
Well, you know, there's probably a case there, because what bus driver is putting a trampoline in the back seat of the car, you know?
Right. It's a very acrobatic kid, right. Okay, we have one final thing before you leave, and that is that we're talking about a lot of people that are moving right now, and they're moving into rental apartments and stuff like that. What kind of an obligation does like a landlord have to keep security in the building? If something happens, you know, your apartment gets robbed and it's in a building.
As a general prospect, a landlord or any property owner does not have a duty to protect you against third-party criminal acts. But they do, however, have there are a lot of exceptions to that. One would be in the case of an apartment, is they're required to rekey or change the locks anytime a new tenant moves in. Also, if they're going to undertake to provide any security, like have a doorman or a buzzer, an intercom system, they have to make sure that that's working properly, because if the locks to the front door aren't working properly, then they can be held liable. So if they undertake to do something like provide lighting, doorman, something like that, they have to do it in a proper manner.
So if the doorman snoozes at midnight, you know, and the robber's walking off with your TV set, you may have a case.
Yes.
That's what I'm thinking. Okay, John, it's always good to have you here. Thank you so much.
Nice to see you.
Every case is different, obviously, so if you do have something that you have a question about, you're interested in finding out what you can do about it, it's Grazian and Volpe, Chicagoland's injury lawyers. They're always there for you. All the legal questions are answered, and all the info is right there on your screen.
Thanks.
Thank you. Thanks for coming in.
Got to tell you, it was great breakfast conversation. I'm done. I'm full. I'm happy. And an author.